Hello. It's great to see you. Have you a great day so far? Hi again. Where have you been? Hey there. It's so great to see you again. I missed you a lot. How have you been? Hello. It's great to see you. Have you a great day so far? Hello. You're looking great as usual. How do you do it? Hello. What have you been up to today?
Hi everyone, it's Stuart Room and welcome back to my YouTube channel on everything to do with data protection, privacy and security. Rugrats, ankle biters, nippers, kids, whatever we may call them, whatever we may think, we all agree that children deserve very special protection in the eyes of the law. And if we recall back to the UN Convention on the Rights of the Child, we'll understand that it is the primary obligation of the state and through all of its organs and facilities to act in the best interests of children. So when we look at the topic of children protection in the data protection, privacy and security field, there are really three areas that we're concerned to understand. One is preventing or protecting children against being exposed to harmful people and harmful content, harmful materials. And we've seen some very significant developments in the course of 2020 on those points, which I'll talk about later. The second concern is about protecting children from being datafied. Now that's a phrase that the UK Children Commissioner has used in 2019 to illustrate the concerns that we have about children being locked into the online environment, into apps, mobile phones and other interfaces, and somehow their inherent journey through life being altered through those engagements. And then of course the third area, which is an area that we're always concerned about in the data protection and privacy field, is the child being subject to surveillance. So who's this little lady? For those who don't know, her name's Cayla and she's an online toy. And within the many embarrassing episodes of my life as a parent, from dad dancing at weddings in front of my teenage daughter, one that is really at the top of the list or close to that point is buying my youngest kid Cayla a few years back, thinking this is a fantastic online toy. Anyway, researchers discovered that Cayla could be hacked. So if we just pull her tummy up, we can see that she has a speaker and there's a device here that you press to be able to engage with her. We've got batteries in the back, and she came with an app, and what happened is you would connect her to the app via Bluetooth and she would connect to the web. You could engage in conversations, and researchers found that the Cayla environment was hackable, and this caused a massive outcry. So a leading privacy activist organisation in the States made complaints about breach of US legislation arising through the absence of parental consent for gathering data. There were complaints to many data protection regulators, and eventually one of the German regulators, a federal regulator for telecommunications, actually banned this device as an unlawful surveillance item and issued statements to the German public, to parents, asking them to destroy this doll. Now, I'm not giving any investment advice. This original doll cost over 50 quid. This isn't the one I bought for my daughter. Its leg fell off. It wasn't that robust. But for the purpose of this video, I went online and bought her on eBay for £2.50. And they're really cheap. So Privacy Pros, get in quick, because I reckon this will be a toy that's worth a bomb in a few years' time. So poor little Cayla is an example of many privacy issues coming together in a single story. So we have the online world of data protection and privacy. And so much of the concern around children protection right now is focusing on the online environment. So we have that. We have the surveillance idea, absolutely critical right now. If you think about the automated facial recognition debates as an example. Data sharing, so you would engage with this as a kid. It would beam up information to web servers. And of course, security, because it was hackable. So in this little lovely lady, we have all of the ills of data protection and privacy and security that we're concerned about when we're talking about children issues. Now, staying with the idea of security for a moment, back in 2007, the UK experienced one of the world's biggest personal data breaches of the time. The government revealed that Her Majesty's Revenue and Customs, a government agency, had lost some data disks that contained full copies of the child benefit database, and that affected 25 million households in the United Kingdom. This is still one of the world's biggest security problems affecting personal data. Of course, with the online environment, we're seeing much bigger growth exponentially on the size of failure. But what I think was really most significant about this case back in 2007 is that it was the point that data protection and personal data breaches crossed the Rubicon from being a matter of geek concern to a matter of mass public concern. And indeed, it was so significant that the then Chancellor of the Exchequer, Alistair Darling, actually had to go before Parliament and explain away the problems. And just thinking back to that time, 2007, I remember that we got a letter through the letterbox, which was a personal data breach notification letter, the first time I'd ever seen one of these things. And that was the moment that essentially a moral panic and mass awareness around data protection really broke through, at least in the United Kingdom. And it was about children data. We're just coming up to the 10th anniversary of another landmark case concerning children. And this was a criminal case in Italy. In February 2010, some executives at Google were convicted in the criminal courts, gaining personal liability in respect of the posting of a video on Google Video that showed a disabled child being bullied. Now, at the time in the data protection community, there was both a huge amount of empathy for the poor bullied child, of course there was, but there was just as much concern, empathy, indeed anger in some places about a situation that could lead to executives, distant executives in the States, being convicted for something completely out of their control. But that kind of case, imagine it today, and where would we be? Particularly with the movement to deal with online harms that we're seeing in the United Kingdom, we may be on a pathway right now that ultimately gets us closer to liabilities for executives and officers and directors of business. Is that a world that we can't predict? I wouldn't rule it out. So what does the law need then? The principal focus of children's specific legislation has been the question of parental consent. So in the United States, the main legislation, COPPA, requires websites and other online businesses to obtain parental consent for the gathering of children data where the child is 12 years of age or below. And for that reason, many online environments in the States have prohibited the use of their platforms by anyone below the age of 13. Europe's taken a similar path to the United States. The GDPR requires parental consent for the gathering of data and the use of personal information in the online environment. Europe can set the bar somewhere between 13 and 16 years of age for the requirement for parental consent. But things are set to move forward, and I think pretty quickly. The UK Information Commissioner has published a new code of practice under the Data Protection Act in brackets, the GDPR for the UK. And this code of practice has evidential effect in regulatory proceedings and legal proceedings. And what it's going to require is website designers, app designers, privacy engineers, coders, etc., working for businesses and organisations operating in the online space to have due regard for that key point of operating and acting in the best interests of the child. So the UN Convention on the Rights of the Child is brought right up to date through this code of practice on age-appropriate design. Now, I've spoken to a few people about this, and some commentators in the data protection space saying, well, it doesn't really tell us anything the GDPR doesn't already require. There are 15 principles. I'm going to put them on the screen so you can see for yourself, form your own view. But I think this code does matter. I think it matters a lot, and I think it adds a lot. Not least, it puts all key information in one place. Secondly, it does go further than the narrow wording of the GDPR, so we get a sense of the detail. And it also tells the question about priority. You see, the government could have required the Information Commissioner, and the Information Commissioner could have had any issue on her agenda to focus on at this stage of the GDPR. But no, it was children data, protection of kids. And I think we've got to really lock into this. We can gain the real sense of priority, the real sense of urgency through the publication of this code of practice. I think it's a really, really good endeavour. I applaud the regulator for bringing it forward. And what this code does, and the reason why I've made this video about the topic, is that it plays to the epicenter of data protection concern. And it's about some of the most vulnerable people in society. So double importance, if you like. And the epicenter for me is privacy by design. Now, privacy by design is expressed as legal principles inside the GDPR using different language. But the essential idea is that organisations should bake in data protections and the desired outcomes into the design framework before they start building new data processing systems, before they start procuring technology. And the thing that has the most resonance for me is that this code is talking at technologists, it's speaking to technologists, it's engaging with data scientists, it's looking at the technology and data layer of data protection. And for anyone who knows me, that is the journey to code. The journey to code is the thing that I believe in. The idea is that all organisations using personal data and new technologies fueled by personal data will inevitably go on a journey, a pathway of discovery that leads eventually to coding in the right outcomes into technology and data themselves. So for people who have asked me, can the journey to code be real? Is it going to be real? When's it going to be real? The answer is it's real now, and this code of practice proves it, in my opinion. But it's also worth remembering that not every organisation needs legislation, regulation and codes of practice to do the right thing, to achieve the right kind of outcomes. There are some fantastic organisations out there right now that are leading on the question of children, data protection and privacy, that are going forward and they're making the right kind of statements and the right kind of progression. And they should be applauded too. And I put some images on screen just to give a sense of what I'm talking about. So there you go, video done. Hope you liked it. And if you did, can you give me a like on the little likey button down there? And don't forget, you can press the bell to subscribe to keep up to date on new content. I've got some really interesting videos coming forward. Well, I say so myself, you may not find them that good. I hope you will stay tuned in. I'm going to be looking at data ethics pretty soon, and also the question of techlash. What does techlash actually mean in terms of the posture that organisations should adopt in public going forward, years ahead into data protection, privacy and security? And also, if you want to know more about these topics, in my new firm, DWF, we're going to be starting our first Tech and Data Leaders Forum on the 3rd of March. So drop me a line, my email's on the screen. Everyone's welcome, you can all join in, and these are going to be really interesting. We're bringing in some very, very special guests into this environment. So I'll be back soon, certainly this time next week. Have a great week.